Remember, the sudden appearance of flashing lights in your rearview mirror is designed to trigger an immediate, high-intensity physiological response, often flooding your system with adrenaline and making it difficult to think with the clarity a legal encounter requires. As the spring season reaches its peak here in late April, the roads are increasingly busy with travelers enjoying the warming weather and the blooming landscapes, which naturally leads to a higher density of traffic patrols and a greater likelihood of these types of interactions. When you see those lights, your primary objective is to manage your own nervous system before you even roll down the window, because a panicked mind is far more likely to volunteer information that could later be used against you in a court of law. Take a slow, deliberate breath and look for the first safe place to pull over, signaling your intent clearly so the officer understands you are complying rather than attempting to evade. This initial phase of the stop is about projecting a calm, predictable demeanor that de-escalates the inherent tension of the situation, allowing you to move from a state of reactive fear into a state of proactive awareness regarding your constitutional protections. Maintaining your composure during these final weeks of April, when the days are stretching longer and the evening commute might still be caught in that tricky transitional glare, is essential for keeping track of exactly what is said and done. A traffic stop is a high-stakes environment for an officer who doesn't know your history or your intentions, and your ability to remain still and keep your hands visible on the steering wheel serves as a non-verbal signal that you are not a physical threat, which can significantly lower the temperature of the interaction. While your heart may be racing, remind yourself that you are in a regulated, legal environment where your behavior and your words are being recorded, either by a body camera or a dashboard system, and every action you take will form the basis of the official record. By staying focused on the physical mechanics of the stop, turning off the engine, dimming your interior lights if it's dark, and waiting for the officer to approach, you create the mental space necessary to listen carefully to their opening questions and avoid the common trap of nervous over-explanation. The anatomy of a typical stop involves a series of calculated observations by law enforcement, and your goal is to provide as little extra material as possible while still appearing cooperative and respectful. Understanding that the officer is looking for signs of impairment, nervous tics, or conflicting stories will help you realize why silence and brevity are often your best legal strategies. This isn't about being difficult or obstructionist. It's about recognizing that the roadside is not the place to argue your case or try to talk your way out of a ticket through elaborate stories. Instead, view this encounter as a formal procedure where your role is to provide necessary documentation while carefully guarding the information that falls under your Fifth Amendment rights. By mastering the art of the calm stop, you set a standard for the interaction that makes it much harder for the situation to spiral into a roadside interrogation, ensuring that if and when the officer asks one of the 4 critical questions we will discuss, you are in the right headspace to provide the only safe answer, a request for legal counsel. Once the officer has reached your vehicle and the initial tension of the pullover has begun to settle, the interaction transitions into what is known as the documentation phase, which is perhaps the most critical window for setting the tone of the entire encounter. As you roll down your window, ideally just enough to communicate clearly and pass documents through, you should maintain a posture that is both respectful and guarded, recognizing that while you have a legal obligation to identify yourself, you are under no obligation to provide a narrative of your day. In the vast majority of states, the law requires you to present a valid driver's license, vehicle registration, and proof of insurance when requested during a lawful traffic stop, and refusing to do so can transform a simple citation into an arrestable offense for obstruction or failure to identify. However, it is vital to distinguish between these administrative requirements and the investigative questions that often follow. When the officer asks for your papers, your response should be verbalized clearly and calmly. For instance, stating that your insurance is in the center console and asking for permission to reach for it is a powerful way to demonstrate that you are not a threat while maintaining control over your physical movements. This level of transparency is not about being submissive, but about being strategically professional, ensuring that the officer has no reason to escalate the situation based on perceived safety concerns. The language you use at the window serves as the primary tool for de-escalation, and adopting a tone of polite neutrality can prevent the officer from finding a behavioral reason to extend the stop into a full-blown investigation. Using formal titles like officer or sir or ma'am is not a sign of inferiority, but a tactical choice to keep the conversation on a professional plane and minimize the friction that often leads to more intrusive questioning. You must remember that every word you utter is being scrutinized for signs of intoxication, nervousness, or deception. So the less you say beyond the necessary exchange of information, the better your legal standing remains. If an officer begins to engage in small talk, asking where you are coming from or where you are headed, realize that these are rarely innocent inquiries. They are often pretextual questions designed to find inconsistencies or establish reasonable suspicion for a search. By sticking to the task at hand, providing the requested documents, and waiting for the officer to process them, you are essentially forcing the stop to remain within its original scope, which is the alleged traffic violation. This disciplined approach requires you to resist the natural human urge to fill the silence or try to justify your driving behavior, as any admission of guilt at the window can and will be used as the primary evidence against you in court. Staying calm and factual during this period involves a high degree of emotional intelligence, as the officer may use various psychological tactics to get you to lower your guard or consent to something you shouldn't. They might act overly friendly to encourage a conversational atmosphere, or they might be stern to see if you react with defensive hostility. But your response must remain the same: a steady, polite refusal to engage in anything beyond the mandatory document exchange. If you have passengers in the car, it is often helpful to have established a quiet car policy beforehand, ensuring that everyone inside understands that only the driver should speak to the officer to avoid conflicting statements or unnecessary distractions. This period of the stop is a waiting game, where the officer is checking your information against their database, looking for warrants or prior records, and your best move is to sit quietly with your hands on the wheel where they can be seen. This visual of compliance, combined with verbal brevity, sends a strong message that you are aware of your rights and are not going to be an easy target for an expanded investigation. You are providing exactly what the law requires, and nothing more, which is the foundational principle of protecting yourself during a roadside interaction. As the officer returns to your window after running your information, you may feel a sense of relief, but this is actually the moment where the most dangerous questions are typically asked. They may hand back your license and then, in a seemingly casual manner, ask if they can take a quick look in your trunk or if you have anything illegal in the vehicle that they should know about. This is the transition from the administrative stop to the investigative interrogation, and your ability to remain firm in your refusal to answer or consent is what separates a routine ticket from a life-altering legal battle. Understanding that you can be polite while still saying, "I do not consent to searches," or "I am not going to answer questions about my travels," is the key to maintaining your constitutional integrity. You have completed the mandatory portion of the stop by providing your ID and paperwork, and now you must pivot to a defensive posture where your silence becomes your greatest shield. The goal of this phase is to conclude the interaction as quickly as possible without giving the officer any additional evidence that could be used to justify a longer detention or a search of your private property. The transition from a routine documentation check to a full-scale roadside investigation often happens so subtly that many drivers don't realize their constitutional protections are being tested until they have already volunteered damaging information. This shift usually begins with the first of the 4 critical questions. Do you know why I pulled you over? While it may feel like a natural way to start a conversation, this is a specific legal tactic designed to secure a spontaneous confession that can be used to justify the stop and any subsequent citations or arrests. If you admit to speeding or failing to signal, you have essentially pleaded guilty on the side of the road, making it nearly impossible for an attorney to challenge the officer's probable cause later. The most legally prudent response is a polite but firm, "No, officer," or "I prefer not to say," which maintains your presumption of innocence and forces the officer to rely on their own evidence rather than your admission. Closely following this is the second question regarding your travels. Where are you coming from, and where are you headed tonight? On the surface, this sounds like polite small talk, but in the context of a traffic stop, it is a tool used to look for indicators of criminal activity. Officers are trained to listen for inconsistencies or overly detailed stories that might suggest you are nervous or deceptive. While you want to remain respectful, you are generally not under a legal obligation to provide a detailed itinerary of your day. In stating that you are simply on your way home or running errands is often sufficient to satisfy the inquiry without opening the door to further interrogation. The third and fourth questions represent a significant escalation into the realm of the Fourth Amendment, which protects you against unreasonable searches and seizures. When an officer asks, "Is there anything illegal in the vehicle that I should know about?" or "You don't have any weapons or drugs in here, do you?" they are fishing for a reaction or a verbal waiver of your rights. If you answer no, and they subsequently find something, even something legal that they misinterpret, They may use your denial as evidence of furtive movements or deception to justify a more intense search. This often leads directly to the fourth and most dangerous question. You don't mind if I take a look around the car, do you? It is vital to understand that consent is a total waiver of your constitutional protections. If you say yes, or I guess so, you are giving the officer permission to search every nook and cranny of your vehicle without a warrant and without probable cause. Even if you are certain your car is clean, consenting to a search is a high-risk move that offers you no legal benefit and only increases your exposure to potential complications. The safest and most professional response is to clearly state, "Officer, I do not consent to any searches." This does not mean you are being combative. It means you are asserting a right that the Supreme Court has upheld for decades. By withholding consent, you ensure that if a search does occur, its legality must be proven in court based on the officer's objective observations, not your permission. Understanding these concepts also requires a high-level awareness of the plain view doctrine, which is a common exception to the warrant requirement across almost all jurisdictions. If an officer sees something incriminating, such as an open container or a weapon, through your window while they are standing in a place they have a legal right to be, they no longer need your consent to enter the vehicle. This is why the de-escalation tactics we discussed earlier, like keeping your interior lights on at night and your hands on the wheel, serve a dual purpose. They ensure officer safety while also helping you keep your private space private. Furthermore, it is important to remember that while the core principles of the Fourth and Fifth Amendments are national, the specific stop and identify statutes can vary from state to state. In some areas, you may have an additional obligation to identify yourself verbally, while in others, your driver's license is the only identification required. However, no state law can compel you to waive your right against self-incrimination when it comes to investigative questioning. Whether the officer is asking about your employment, your associations, or your past, you have the right to remain silent and request the presence of an attorney. Recognizing these boundaries isn't about hiding anything. It's about participating in the legal system as a knowledgeable citizen who understands that the roadside is a place for procedure, while the courtroom is the place for arguments and evidence. When the tone of a traffic stop shifts from a procedural inquiry into an aggressive investigation, you are approaching what is known as the escalation edge, a critical moment where your physical safety and your legal rights must be balanced with precision. This often happens when an officer asks you to step out of the vehicle or begins to ask pointed, accusatory questions that go beyond the scope of a traffic violation. It is essential to recognize that while an officer can generally order a driver and passengers out of a vehicle for safety reasons during a lawful stop, this command does not automatically strip you of your right to remain silent. If you find yourself in a situation where the officer is pressing for information or trying to corner you into an admission, the most effective and protective action you can take is to clearly and unequivocally state that you will not be answering any further questions without the presence of an attorney. This statement is a formal invocation of your constitutional rights, and once it is made, the interrogation is legally required to stop. You must realize that at this stage, the officer is no longer your assistant or a neutral party. They are actively gathering evidence, and any attempt to clear things up or be helpful will likely only provide them with more material to build a case against you. By remaining silent and requesting counsel, you are essentially hitting a legal pause button, ensuring that your words cannot be twisted or taken out of context before you have had the chance to consult with a professional who understands the complexities of the law. Staying safe during these high-tension moments requires a commitment to physical compliance, even when you are verbally asserting your rights. There is a profound difference between being legally non-compliant, such as refusing to consent to a search, and being physically non-compliant, which can lead to immediate danger. Even if you believe the officer is acting outside of their authority or that the stop is entirely baseless, the side of the road is not the place to argue the merits of the law or to resist an officer's physical commands. If you are told you are being detained or arrested, do not pull away, do not reach for objects, and do not make sudden movements. Instead, comply with the physical directions while maintaining your verbal silence. You can state, "I am not resisting, but I am remaining silent, and I want my lawyer," which creates a clear record on any body camera or dashboard audio that you are being cooperative with the physical process while fully retaining your legal protections. Resisting an officer, even if the arrest is later found to be unlawful, can lead to separate criminal charges and, More importantly, can escalate the situation into a physical confrontation where your safety is at risk. Your goal is to survive the encounter with your health intact and your legal options preserved, allowing the battle to be fought in a courtroom where the rules of evidence and the oversight of a judge provide a much fairer environment than a dark highway. During an escalation, it is also your responsibility to be a factual observer of the events as they unfold, which means keeping a mental or even a digital log of the officer's behavior and the timeline of the stop. If you can do so safely, note the officer's name, badge number, and the patrol car number, as well as the names of any other officers who arrive on the scene. If you have a passenger, they can act as a witness to the exchange, but they must also remain calm and follow the same principles of silence and physical stillness. In many jurisdictions, you have a right to record the police as long as you are not interfering with their duties, but you should always prioritize safety. Keep your phone in a mount or inform the officer before reaching for it to avoid any misunderstanding. This documentation mindset helps you shift from a victim of the situation to an active participant in your own defense, providing your future attorney with the raw data they need to challenge any overreach. Remember that the escalation edge is where many people lose their cool and say things they later regret. By staying factual, staying quiet, and staying safe, you maintain the upper hand in the legal long game. You are not just a driver at that moment. You are a citizen, exercising the very rights that were designed to protect you during exactly these types of high-pressure interactions. The moment the officer returns to their vehicle and the encounter concludes, your immediate priority should be to find a safe location to pull over and document every detail of the interaction while the memory is still vivid and the adrenaline is still circulating in your system. This post-stop phase is perhaps the most underrated part of your legal strategy, as your contemporaneous notes can serve as a powerful tool for your defense if the stop results in a citation or criminal charges. While it may be tempting to simply drive away and put the stressful event behind you, taking 10 minutes to record the specifics of the encounter can make the difference between a successful legal challenge and a missed opportunity. Begin by noting the exact time and location of the stop, including any specific landmarks or cross streets, as well as the environmental conditions like visibility and traffic flow at the time. You should write down the name and badge number of the primary officer and any backup officers who arrived, as well as the unit number on the patrol car if you were able to see it. Most importantly, try to transcribe the dialogue as accurately as possible, focusing on the specific questions the officer asked and the exact words you used to respond. Did the officer ask for consent to search? Did they explain the reason for the stop immediately, or did they wait until after they had questioned you? Did they return your documents before asking one more thing? These nuances are the building blocks of a legal defense, as they can reveal whether the officer exceeded the lawful duration of a traffic stop or violated your Fourth Amendment rights. Having a documentation mindset means understanding that your memory is fallible, especially under the high-stress conditions of a police interaction, whereas a written record created immediately after the fact carries significant weight in a legal context. If you were issued a ticket, keep it in a safe place and do not write on it or alter it in any way, as it contains essential information like the officer's identification and the specific statutes you are alleged to have violated. If you recorded the encounter on your phone, ensure that the file is backed up to a secure cloud service and do not share it on social media until you have consulted with an attorney, as publicizing evidence before a case is resolved can sometimes complicate your legal standing. Beyond just the dialogue, note the officer's demeanor and any physical actions they took, such as where they placed their hands, whether they used a flashlight to look inside the car, or if they reached inside the vehicle at any point. This level of detail allows an attorney to reconstruct the scene and identify potential procedural errors that might not be apparent to a layperson. By treating the aftermath of the stop with the same discipline you used during the interaction itself, you are providing yourself with the best possible chance of a favorable outcome in the judicial system. Your goal is to create a clear, factual, and unbiased account that can be used to hold the system accountable and ensure that your rights were respected from the moment the lights flashed until the moment you drove away. Finally, it is essential to internalize a critical boundary. While this information is designed to provide high-level educational concepts regarding your constitutional rights and common law enforcement procedures, it is absolutely not personalized legal advice. The legal landscape in the United States is a complex patchwork of federal precedents and state-specific statutes, and what constitutes a lawful procedure in one jurisdiction may be handled differently in another. The principles of remaining silent, refusing consent to searches, and identifying yourself are broad constitutional protections, but their application can vary wildly depending on your local laws, city ordinances, and the specific facts of your situation. This presentation does not create an attorney-client relationship, and you should never rely solely on a video to navigate a criminal or civil legal matter. Every case is unique, and the only way to ensure you are making the best decisions for your specific circumstances is to consult with a qualified, licensed attorney in your area who can review the facts and provide tailored guidance. Laws regarding traffic stops, search and seizure, and driver obligations are subject to change through legislative action and court rulings, making it vital to seek current, local counsel if you are facing legal consequences. Use this education as a foundation for your awareness, but always defer to professional legal representation when your rights, your record, and your freedom are on the line.